President, I rise today to discuss international data privacy. Now, this is a critically important issue that has become all the more important over the years as we've become more sophisticated. But it's been pressing in recent months as a result of the court decisions impacting law enforcement's ability to access electronic communications overseas. I don't think it will surprise anyone, Mr. President, to hear me say that our privacy laws have not kept pace with technological developments. The primary statute that governs law enforcement's ability to access electronic data, the Electronic Communications Privacy Act, or ECPA, was enacted over 30 years ago, long before most people had even heard of email or the internet. ECPA was drafted in a world in which electronic data was stored on personal computers or on servers located in offices or homes. It presumes a world where data is in one location and where, in order to access data, a person simply goes to the relevant location and retrieves it. But that is not the world we live in, at least now. Nowadays, much of our data is stored not on home or office computers, but in the cloud, a network of remote servers spread throughout the world that allows us to access data from literally anywhere. The rise of cloud and remote network computing has transformed the way companies and individuals store data. No longer is data stored on site or in one discrete location. Rather, data pertaining to a single individual or even to a single document may be stored at multiple sites spread across countries or even across continents. This has created all sorts of complications for our laws. ECPA requires law enforcement to obtain a warrant before it can access many types of electronic communications. It also prohibits disclosure to foreign entities. Warrants, however, traditionally have stopped at the water's edge. A judge here in Washington can issue a warrant authorizing law enforcement to search an office here in Washington, but cannot issue a warrant for searches in London or Paris. So what is law enforcement to do in a world of cloud computing where pieces of the same electronic document might be stored in Washington, London, and Paris? One possibility is to say that as long as the data is accessible from the United States, that is, so long as you can retrieve it by logging onto a computer somewhere in the United States, that's all that matters. Law enforcement can order its disclosure. This sort of maximalist approach, however, brings with it a whole host of problems. To begin with, it pays scant attention to the laws and interests of other countries, including our closest allies. Other countries, it turns out, have data privacy laws of their own. And just like ECPA, sometimes these laws prohibit disclosure to foreign entities, including foreign law enforcement. So to say U.S. law enforcement can compel disclosure of data stored anywhere in the world so long as that data is accessible from the United States is really to say that U.S. law enforcement can override the laws of other countries. Or more particularly, it's to say U.S. law enforcement can order individuals or companies that store data overseas to violate the privacy laws of other countries. Now, this is unfair to service providers who may find themselves on the wrong side of the law no matter which side they choose, and does little to help international relations. It also undermines trust, drives customers to foreign competitors, and undermines the privacy of U.S. citizens by emboldening other countries with less robust privacy regimes to similarly seek unlimited extraterritorial access to data. Another possibility is to say that if the data is stored in the United States, then law enforcement may access it. But if it's stored outside our borders, it's off limits. This is essentially the current state of affairs following a decision last summer by the U.S. Court of Appeals for the Second Circuit that ECPA warrants do not reach data stored abroad under the Second Circuit's decision. U.S. law enforcement can use compulsory process to access data stored in the United States, but must work through diplomatic channels to obtain data stored overseas. This sort of domestic storage regime has the benefit of avoiding the conflict of laws problems that I've just described, but it also has very real drawbacks. To begin with, it impedes law enforcement's ability to solve and prevent crime in cases where the needed data is stored outside the United States, even when the creator of the data is an American. The service provider storing the data is an American, and the crime being investigated took place here in the United States. The mere happenstance that the data is stored beyond our borders, even though it may constantly or instantly be accessed from within our borders, places it off limits. Service providers' varying business practices in moving and holding data determine whether an investigation moves forward. This sort of domestic storage regime also forces U.S. law enforcement to work through diplomatic channels, which sometimes are slow and sometimes very cumbersome, and in many instances less protective of privacy than U.S. criminal process, which requires a warrant from a neutral magistrate and a finding of probable cause. The upshot, Mr. President, is that neither of these regimes is satisfactory. A maximalist regime that extends U.S. law enforcement jurisdiction worldwide creates serious conflict of law problems and places U.S. service providers in impossible positions. A more modest domestic storage regime, by contrast, hinders law enforcement's ability to solve crime and protect us from harm based solely on where a particular document or piece of data happens to be stored at a given moment in time. What we need, Mr. President, is a sensible regime with clear rules that determine access based on factors that actually matter to the person whose data is being sought. Privacy laws are meant to protect people, not abstractions. We ought not get bogged down with mindless formalism. Most people couldn't care less whether their data is stored at site A or site B, or country A or country B, so long as it's easily accessible and has robust privacy protections. At the same time, we need to take proper account of the laws and interests of other countries, especially our allies. We ought to avoid, where possible, trampling on other nations' sovereignty or ignoring their own citizens' legitimate claims to privacy, whether here in the United States or abroad. For this reason, Mr. President, I believe the right approach to international data privacy is to ground the analysis on the location of the person whose data is being sought. It is, after all, the person who has rights and the person whose interests are devalued when data is obtained without proper process. Accordingly, I've proposed legislation called the International Communications Privacy Act, or ICPA, that sets clear rules for when and how U.S. law enforcement can access electronic data based on the location and nationality of the person whose data is being sought. I intend to introduce an updated version of this legislation in the very near future. Here's what the updated legislation will say. If a person is a U.S. national or located in the United States, then law enforcement may compel disclosure no matter where the data is stored, provided the data is accessible from a U.S. computer and law enforcement uses proper criminal process. If a person is not a U.S. national, however, and is not located in the United States, then different rules apply. These rules are founded on three principles: respect, comity, and reciprocity. First, respect. If U.S. law enforcement wishes to access data belonging to a non-U.S. national located outside the United States, then law enforcement must notify the person's country of citizenship and provide that country an opportunity to object to the disclosure. This protocol shows respect to the other country and gives the country an opportunity to assert the privacy rights of its citizen. Second, comity. If after receiving notice the other country lodges an objection, the U.S. court undertakes a comity analysis to determine whose interests should rightfully prevail: the U.S. interest in obtaining the data or the foreign interests in preventing disclosure. As part of this analysis, the court considers such factors as the location of the crime, the seriousness of the crime, the importance of the data to the investigation, and the possibility of accessing the data through other means. This analysis prevents an obstinate foreign power from impeding investigations without good reason or where the U.S. interests in disclosure are particularly strong. Third, reciprocity. In order to receive notice and an opportunity to object, the other country must provide reciprocal notice and objection rights to the United States. The country must provide robust privacy protections within its own borders and satisfy international human rights standards. These requirements ensure that the U.S. provides its own citizens an equal or greater level of protection against foreign requests for data. They also offer incentives to foreign governments to properly safeguard the data of U.S. citizens within their jurisdiction. Tomorrow, the Senate Judiciary Committee, Subcommittee on Crime and Terrorism, will hold a hearing on law enforcement access to data stored abroad. That hearing, I hope, will elucidate many of the principles I've just described. Soon after the hearing, I will reintroduce the International Communications Privacy Act. The bill, as reintroduced, will incorporate feedback from law enforcement and privacy groups. I intend to push very hard for this legislation, Mr. President, and will seek every opportunity to do so. I want my colleagues to know that I will be pursuing any and all legislative vehicles to get it across the finish line. In the words of Utah businessman Jeff Hadfield, writing in the Deseret News, quote, "It's imperative that Congress quickly address the ambiguity within our current law. As every company becomes a software company, we need legislation that supports our company's ability to store data overseas, protects our individual privacy rights, and help U.S. law enforcement do its important job," unquote. I could not agree more. The International Communications Privacy Act provides critical guidance to law enforcement while respecting the laws and interests of our allies. It brings a set of simple, straightforward rules to a chaotic area of law and creates an example for other countries to follow. It is a balanced approach and a smart approach, and it deserves this body's full-throated support.